Do you have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24.
Well, hello there, and welcome once again to Ask a Lawyer here on CP24. I'm your host, John Scholes, and momentarily we'll get Chris Justice on here. It's the best handle ever for the job, and Chris is an amazing lawyer from EmploymentLawyer.ca. He will be doing all the heavy lifting and answering of questions on the show this week as well, so stay tuned. In just a couple of minutes, we'll meet Chris. You met him before. He's been on the show before, and anytime we're not doing this a half hour, you can always reach out to Chris and his crew. Simply 1-888-861-4555, ask@EmploymentLawyer.ca, and the website built just for you. It's free, it's anonymous. You can learn tons on it as well, called PocketEmploymentLawyer.ca. We always shadow the mist. We pull back the curtain on employment laws, which are really actually robust, and they're good in your favor, but it's like anything else, right? If you don't know about it, you can't take advantage. So that's why we do the show here every week on CP24 to educate you. A little later on the show, our main topic for this week is going to be 5 things that an employment lawyer can do that you probably can't. We're being generous with probably, but you're going to want to know these 5 things, so stay tuned for that. And some phone calls from our radio shows across the country, but we focus primarily right here in the GTA on News Talk 1010, Sundays at 1 p.m. You are invited to join the show. Call in, ask your questions. They may appear here on a later date as well. So that and lots more coming up here. But Chris, we always start every show. We get warmed up, as they say, a little employment law CrossFit with the week that was, brother. What do you got going on?
Yeah, first of all, just thanks again for having me, John. As you know, I get inundated with calls pretty much day in, day out from people from all walks of life dealing with all sorts of employment law issues. You know, whether it be something you're going into a relationship wondering about, maybe you're experiencing something during the tenure itself of employment, or you've got a question or two on your way out. Whatever it ends up being, it just goes to show how impactful employment law is and can be on most of our daily lives, and why it's therefore important that people know what their rights and entitlements are, hence why we're here today, to hopefully shed some light. So I do have a case that came across my desk the other day I did want to talk about off the top. It has to do with performance improvement plans, otherwise known as PIPs. I had a gentleman come to me, call me up, asking about, you know, what his rights, what his options were. He had been given a PIP by his employer. He had been told to sign the PIP, otherwise he'd be let go. And as many people can understand, that put a lot of stress on this individual. He actually took a lot of issue with the PIP itself. He had some issues as far as the criticisms that were levied against him, and he just wasn't comfortable signing it. And so he came to me wondering what his rights were, because just after getting the PIP, he also went on a stress leave. And so, you know, the company said, once you get back, we're going to put you back on the PIP. And so again, hence why he reached out wanting to know what his rights were. And so I wanted to kind of raise this as a little bit of a PSA for those who have been presented with a PIP that they actually believe is not reflective of the actual situation. So maybe the criticisms are untrue, maybe they're misrepresented, maybe there's some sort of context that needs to be provided. Just like in this guy's case, he didn't think the criticisms were fair. And the important thing in this situation is to make your voice heard. You know, put it in writing, write an email, write a letter, doesn't matter, but make your voice heard, put your objections down so that you're not going to be in a situation later on where it's he said, she said, and the company's going to say, look, we didn't know that you disagreed with the PIP. We thought you're okay with it. You don't want on the face of it for it to seem like you've agreed with the PIP, nor do you want to sign something saying you've agreed with it. You know, it's one thing to say, I've received the PIP. I acknowledge having, you know, understood what the PIP is saying, but it's entirely different for you to actually agree to the criticisms themselves. So you want to state on the record what your position is so that later on, if that company decides to use that PIP to let you go for just cause, it's going to be much more difficult to do, and you're going to be able to protect and preserve your rights moving forward.
All right, as we mentioned, phone calls. We get to a few of them on the show here for every half hour. We do this every week. And again, you want to find a station near you, including right here in the GTA, News Talk 1010, Sundays at 1. Simply go to EmploymentLawyer.ca and you can tune in and phone in and join the show as well. Chris, I want to get to the first phone call now and pick it apart and get your opinion on it. It's coming right now.
Company hired me for independent contractor for 5 years, and then they make me a full-time employee. Now the company is being sold. They are only giving me a severance for only the last 6 years. Am I entitled for the whole 11 years?
How much have they offered you?
Only 4 months.
Yeah, so it's a good situation. It's one that I find happens a lot, unfortunately, where there is a misclassification of somebody as an independent contractor. You know, your employer may be telling you that you're an independent contractor. You may yourself think you're an independent contractor, or there might even be a contract you sign which labels you as much. But the law is ultimately what's going to decide whether or not you're an independent contractor. And there's a lot of factors that go into determining if somebody is an employee or not. And it's very important because the difference between an employee and an independent contractor, especially in the context of a termination, is that the employee is entitled to severance, whereas the independent contractor isn't. You know, sometimes I have situations where people are told they've been an independent contractor their entire time at a company, and then other times we've got something like this caller where maybe they're being told a portion of their tenure has been served as an independent contractor, and the company then looks to try and discount that amount of years of service for purposes of paying out severance, which seems like exactly what's happened in this particular caller's case. And the good news is that for the most part, vast majority of cases I see where people are being alleged to be independent contractors, it's just simply not the case. They're actually, as far as the law is concerned, an employee, and all years of service with that company should be included. And if we look actually at the Pocket Employment Lawyer Board, we can pull it up on the screen, we can see that by including the years that this gentleman was told are being served or were being served as an independent contractor, you've got a total length of employment there as 11 years, and you see down below their compensation owed being 12 to 14 months. Not just a few months like this gentleman's received, but over a year of severance, and that's because those years have been factored in. And that's why it's all the more important if you're in a situation like this to get employment law advice from an experienced lawyer so that, again, you best protect and preserve your rights moving forward.
Let's get into a short break, Chris, and we'll be back after the break with 5 things an employment lawyer can do that you probably cannot. I'll give you the contact information again as we get into the break to reach Chris and his crew anytime, 1-888-861-4555. Email is ask@employmentlawyer.ca. And as Chris just mentioned, that website, pocketemploymentlawyer.ca as well. We'll continue more of Ask a Lawyer right here on CP24.
You have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24.
Okay, welcome back. Thank you for sticking around. Ask a Lawyer here on CP24. To reach out to Chris Justice anytime, you can do so on your own time. Have that conversation. 1-888-861-4555. Ask@employmentlawyer.ca as well. As we mentioned, the main topic for this week, 5 things an employment lawyer can do that you probably cannot. Number 1, let's get right into this, Chris. Secure a fair severance package. That'd be a good one.
Yeah, it's very important. Obviously, it's a lot of what we at the firm do. You know, we help negotiate better severance packages for individuals. And it's important because probably 90+% of the time, you know, if you're being offered a severance package, there's, in all odds, it's going to be way less than what you're actually entitled to. You're probably being offered pennies on the dollar when you should be going after far more. And that's why it's very important that you get an employment lawyer involved, you know, especially someone with experience. They've done it before. They know how employers react in these scenarios. You know, you get the employer's legal counsel on the phone, and you're usually, for the most part, able to hash out a deal that doesn't require any lengthy amount of time or litigation. And people know that, or need to know rather, that you can get upwards of 24 months as an employee. So unfortunately, it's not like we're talking often about the difference between maybe 3 weeks and 5 weeks. It's more like between 3 weeks and 6 months, or between 12 weeks and a year. So we're really talking about tens of thousands of dollars in a lot of cases. And you definitely want to make sure before you sign off on any severance package that you are actually receiving something that's fair and reasonable.
The second thing your employment lawyer can do is evaluate that minefield we call an employment contract, right?
Yeah, employment is obviously a very important part of our lives, and that contract is what's going to govern the working relationship that we have with the employer. And a lot of times people will be so excited about getting a job, they'll be wondering, okay, how much am I going to get paid? What are my benefits? But then they may miss little things like, oh, this termination clause in this contract, what does that have to say? you're not really thinking about things like termination on your way into an employment relationship, but you need to be thinking about it because on your way out, should that happen, you could be letting go, thousands and thousands of dollars, not really understanding or appreciating the effect it could have. There's other clauses in contracts that could allow the company to change the terms of your employment as well that you need to be aware of, so that you're not signing up for one thing only to find out later on that it's being changed and that the company is now suggesting that the contract you signed gives them the ability to make those changes.
Number 3, an employment lawyer can identify when you've been constructively dismissed. How about that one, pal?
Yeah, so a constructive dismissal is a substantial change to the terms of your employment that you don't agree with. And an employment lawyer is going to be able to tell, depending on what the change is, whether it's a significant change, enough that would amount to a constructive dismissal. It could be a change to your hours, it could be a change to your pay, your location, the job itself. And if ultimately you are in a situation where you've been constructively dismissed, you're going to generally look at the same amount of compensation you would get as though you've been let go without cause. And you also want a lawyer in these cases so that you don't communicate with your employer certain things that might end up doing harm to yourself. You want to make sure that you communicate the right things, that you definitely don't quit in the face of any substantial changes, and again, you seek that legal advice first.
Again, an employment lawyer can do number 4 as well, that help if your human rights have been violated, yeah?
Yeah, so I think it goes without saying that, violating human rights is illegal. It's against the human rights legislation. It's a big problem. But I think an employment lawyer comes in handy when going through the different types of discrimination you can face. A lot of people actually think that because they're being treated differently, that automatically that means discrimination for purposes of human rights, when there actually isn't a protected ground under the Human Rights Code that's at play. And so a lawyer can take you through the protected grounds under the legislation. A lawyer can let you know how much time you have to file a human rights complaint. And again, make sure that you get what's fair and deserved.
We were talking about 5 things an employment lawyer can do that you probably cannot. The 5th and final one for this show anyway is give your employer that proverbial kick in the pants when they need it, right?
Yeah, there are definitely situations where somebody on their own may be able to get what their desired outcome is, but it's very rare. And unfortunately, oftentimes the employer does need a bit of a kick in the pants from an employment lawyer. I said before that at that point, legal counsel is going to get involved. And sometimes that lawyer on behalf of the employer is going to notify them as to some errors that they've made. Maybe there's an issue with overtime, vacation, severance. But that extra little kick in the pants that your employment lawyer can give adds some credibility, adds some weight behind the words, and is usually effective in resolving disputes.
Again, a lot of this information can be found at PocketEmploymentLawyer.ca, so check that out at your leisure. Let's get into phone call number 2 now for the show. Hang on.
My employer right now is looking to reduce my commission structure by more than half of what it is right now. I'm just curious if this is something they can do or if they have to compensate me in another way to make up for that. They were looking to offer minimal bonuses that don't seem to even come close to what the potential is on the commission structures.
Yeah, so this caller situation is pretty much describing a constructive dismissal, specifically in the context of a commission. So again, unless there is some consent on your end as the employee to agree to that pay cut or that commission cut, that's going to amount to a constructive dismissal. And if you're in that situation, you're going to have the ability to either agree to that change, potentially negotiate a change, or stand your ground and say that that's not what you signed up for initially, and that by virtue of that employer imposing that change on you, you may have the ability to leave that situation and get your full severance as though you were let go.
All right, we'll take one more short break, or at least another short break. Now we'll get into phone call number 3 on the other side, so stick around for that. In the meantime, reaching out to Chris and his team. Here's that number again, 1-888-861-4555, and ask at EmploymentLawyer.ca. This is Ask a Lawyer here on CP24.
You have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24.
Welcome back to Ask a Lawyer here on CP24. John Scholes, your host, and Chris Justice from EmploymentLawyer.ca. Reach out to Chris anytime when we're not doing this half hour. How you do it? 1-888-861-4555. Ask at EmploymentLawyer.ca. And just EmploymentLawyer.ca. You want to find a radio station in your vicinity that carries our radio show, long-running radio show for over a decade now, including Sundays, 1 p.m. right here on News Talk 1010. Call in, join the show, and maybe your call will appear on air right here, which we're going to get to right now. By the way, phone call number 3 is coming up.
Actually, I just got let go today from my employment. 20 years. It was a sales job, and I'm 60. And employee benefits, they gave me 2.5, 3 months of continuation.
Yeah, so this seems like an example of what I was earlier describing, where the employer is giving you pennies on the dollar. You know, we've got a very long service employee who's 60 years of age, perhaps making a decent amount of money at the company, and they're being offered a pittance in relation to what they're probably generally looking at. And if we turn back to the Pocket Employment Lawyer Board, we can see that, you know, when you factor in those key stats like the person's age, the job, compensation, length of employment, you see there at the very bottom what their potential severance owed is. And again, that's just why it's fundamentally important that people review severance packages with a lawyer before signing off, even if they think it looks like a reasonable amount, because in this gentleman's case, there is a huge difference between what is being offered and what's ultimately awarded or should be awarded to him.
I want to get to a question, Chris, you had recently. It's a good one. Sel says, Chris, I had a near mental breakdown at work last week. Due to the workload, my boss gave me 2 choices on the spot, a demotion and a pay cut, or lose my job. I chose the second option. My employer knows the stress I'm under, but instead of trying to help, I was pushed out the door without severance. Nice boss.
Yeah, nice indeed. I mean, the thing about resignations, as many people know, is that they need to be voluntary. They need to be unequivocal. And when you essentially push somebody out or push somebody in the direction of quitting as a result of a situation like this, that is not going to be seen as a resignation in the eyes of the law. It's going to be seen likely as a constructive dismissal, because it really isn't much of a choice. It's the illusion of choice, right? They're being offered a demotion, something that's a substantial change from what they were used to before, or the door. And so it's very unlikely that your employer is going to be able to rely on any of that to take effect as a real resignation. And someone in this caller's situation is, very likely looking at a lot of severance for that forced resignation.
We'll take one more quick break, get to a little more here on the show. Here's the number to reach out to Chris and his crew. Again, 1-888-861-4555. It is ask@employmentlawyer.ca or pocketemploymentlawyer.ca online. Use that website. It's free and anonymous, and it teaches you a lot of what we talk about on the show every week as well, as we continue with Ask a Lawyer here on CP24.
You have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24.
Welcome back indeed. This is Ask a Lawyer on CP24. I'm John Scholes. Chris Justice is a lawyer joining me this week. Chris does a lot of live streaming on Facebook and YouTube. You can join in as well. Go to stlawyers.ca to do that. Here's the question for this week, Chris. It says, I gave my employer a 4 years notice that I'm leaving in 2 weeks to join a competitor. Unfortunately, I just noticed a non-compete clause in my employment contract. What happens now?
Yeah, it's a good question. A lot of people come to me wondering, there's this non-compete in my contract. Is it enforceable? I've just been let go. I want to actually go out and look for work, but this non-compete's affecting my ability to look for work. It's affecting the available opportunities that are out there for me. What's the deal with the non-compete? And fortunately, for the most part, if you're somebody who is arguably subject to a non-compete clause, there's a good chance that it won't be enforced. As of now, at least in Ontario, and as of the latter half of 2021, non-competes were actually banned. And even before that, the law typically doesn't like non-competes for the reason I mentioned earlier, which is it puts a restraint on your ability to seek out new employment. And so even if you're somebody who might have signed a non-compete or a contract with a non-compete before the ban took effect, as I say, there's a high likelihood that that non-compete won't stand up, because it's the employer actually in these situations that needs to prove that the non-compete is reasonable. And the way that they do that, or the way that the courts assess whether or not a non-compete is reasonable, if you even get this far in the analysis, is to look at things like how long is it in play for. So a non-compete that's maybe 2 years in duration is going to be much less likely to be upheld than one that's maybe a few months to 6 months. Then there's other issues in terms of in what capacity can you compete or not compete? Can you work for a competitor, let's say as a janitor, even though you had a director role with the former company, or is it just only in certain roles that you can't compete with that organization? And then there's also a geographical scope to the analysis as well. So Is the non-compete saying that you can't compete, let's say, in a 15-kilometer radius from downtown Toronto, or is it saying you can't compete with us globally or within North America? So these are just some of the main factors that the courts look at when determining whether a non-compete should be upheld, assuming it didn't come into play after 2021. And again, that's going to be, for the most part, on the employer to show that it's reasonable. So if you are somebody in a situation where you think you have a non-compete that might apply to you, you definitely want to give us a shout either way so that we can make sure that it's not an issue going forward and that you're going to be able to, of course, seek out all those opportunities and hopefully find a job sooner rather than later.
Yeah, I think the key thing is to reach out, because some people, after hearing that, would think, oh, I can just ignore this then if it's not going to hold water, right?
Yeah, and you know, while it may likely be the case that the company can enforce the non-compete, and it may likely be the case that the company's not going to pursue the enforcement of that non-compete, you also don't want to have it just lingering out there, potentially creating a headache for you. You want to make sure, with the help of an experienced employment lawyer, that at the very least that can be confirmed as being a non-issue, that the employer is not going to go after you with respect to that non-compete. And as I say, the law, fortunately, is on your side when it comes to putting together a number of arguments as to why those non-competes should not be enforced. But again, all the more reason why you should be getting legal advice before deciding to do anything moving forward.
Just play it safe, man. We always say play it safe, right, if you're going to choose that.
Yeah, absolutely.
And that is about all the time we have for today. Thank you so much for your contributions through emails or otherwise. You want to reach out to Chris on your own time, and his crew, very capable, always ready to have that conversation with you. The phone calls first, 1-888-861-4555. You can email ask@EmploymentLawyer.ca. And that free anonymous website built to make you smarter, educate you, PocketEmploymentLawyer.ca. There you'll have access to the severance calculator and any other information you need. You can get it on radio too. Reminder, right here in the GTA on News Talk 1010 Sundays at 1 p.m. And for anything else, it's cp24.com/ask a lawyer. Thank you so much, and we'll catch you next week right here on Ask a Lawyer once again.